This is the American Law Journal.
35 years ago, there was only one way to get pregnant and have a kid. But today, through science, that's all changed. And with it has come a new legal Wild West. And lawyers and judges and legislatures are doing their best to keep up. Good evening and welcome to the American Law Journal. I'm Christopher Naughton. This week, assisted reproductive technologies and the ability to procreate children by medical instead of simply sexual means has been a boon to a large segment of our population, some 10%. But the law to deal with this issue has been evolving slowly. Three great guests with me tonight. Let's go ahead and meet them. Bonnie Frost hails from Einhorn Harris, Asher, Barbarito, and Frost, one of the largest, if not the largest, family law practice in the state of New Jersey. Bonnie has headed her State Bar Association family law section on a number of occasions, and currently she is the chair of the Matrimonial Mediation and Arbitration Department at Einhorn, and now has 27 published cases to her credit. Juanita Kness joins us for the first time this evening, Reproductive Medicine Associates of Pennsylvania. She's a nurse practitioner with a doctorate, and she's in the private practice to help build families. And Don Spry returns once again, as he's been doing for some 20-odd years. From King Spry, Herman Freund and Fall, I like to call him the dean of family law in Pennsylvania. I know it makes him blush a little bit, but Don has been a stalwart here on the program, and he has lent his experience and his wisdom in this family law area for many years. This topic tonight is kind of the reason that you folks probably got involved in law. You may not have known that many years ago, but this is so wide open. Assisted reproductive technology, it's wide open, it's virgin. I don't know what metaphor you want to use, but really it is kind of a legal Wild West. I don't want to say you're making it up as you go along, but you and judges are kind of making it up as you go along.
Lawyers are advocating for rights of clients that are involved in these proceedings, and judges and the courts, at least in Pennsylvania, the law with respect to assisted reproductive is case-driven. We don't have statutes, so it's all coming before the courts.
Right. So the legislature really hasn't opined on this. This is all lawyers and judges going, where are we going on this one, Bonnie? Same thing in Jersey, right?
Same thing in New Jersey. We do not have any statutes dealing with any of these topics. And so what's happened is that we've had to apply statutes that we have, and sometimes it's fitting a square peg in a round hole.
And this is always an interesting thing about the law, stare decisis and making sure that you look to precedents. So you go back to maybe cases out of the 60s, talking about the reproductive rights of individuals. Maybe some of that wisdom, gets put in a brief, gets put before a court. I mean, you got to tap into something.
Yeah, I mean, you have an interesting situation for years in Pennsylvania. It would be against public policy to bargain away a child's rights.
Right.
We have sperm donors in Pennsylvania, and they entered into contracts saying that they would not be obligated to support a child that results. And the first battleground was, well, is that against public policy? And the court came down saying, no. That public policy was established for the old days where you had babies one way. Now it's technological, so we're not going to have donors if they're going to be responsible for supporting offspring.
Right.
In these circumstances.
Sure. And Juanita, for you, not literally speaking, but figuratively speaking, you don't even want to see people come into your private practice if they don't bring their lawyer and their psychologist with them.
That's correct. The technology allows for creating embryos using sperm, using donor eggs, using gestational carriers. So all of those issues require a strong legal and psychological evaluation and education of all of the parties involved, whether it be the donors or the intended parents.
So in some ways, I mean, I've seen the informed consent reform, so anyone who wants to engage the services of your organization, they literally have got to look through 27 pages of information. And again, by the time they come to see you, they already have seen a psychiatrist or psychologist or some sort of therapist. They already have legal representation by the time you engage in a contractual arrangement with this client.
Yes. The American Society of Reproductive Medicine is kind of our professional organization, and they issue many practice guidelines and ethical guidelines for us, and they very strongly recommend that everyone who undergoes assisted reproduction in any way have psychological evaluation. Now it's up to the individual clinics, but I can tell you that we really want to ensure that everyone enters into this understanding what they are getting into, what the ramifications are for them, for the future children they create. So it's to everyone's best interest to have that counseling and evaluation.
And certainly that informed consent form that they have to sign could become a court document somewhere in the future.
Absolutely. And that's one of my roles is I sit down with every patient who is undergoing any kind of in vitro fertilization, and we go through the informed consent line by line, page by page, and it takes a very long time because they need to understand all of the information that's in there and make sure that you're getting true informed consent. There's nothing worse in healthcare than a patient who can prove that they didn't have true informed consent.
Juanita, I read that informed consent, and it was, aside from the side effects of some of the medicine that's used, it really is sort of a roadmap of checkoffs of the type of issues that can arise. Situations where a person is getting divorced and they have embryos, the question becomes what happens to those. I know a lot of states have said that they'd be destroyed because you don't want to make someone a parent who doesn't want to be a parent. And Pennsylvania, they used a balancing test and they distributed the embryo to the wife because prior to chemotherapy, she had used her egg to create the embryo and would not have been able to have children after the chemotherapy. So that balancing test, the court permitted her to keep the embryo.
Right.
In the case in New Jersey, they decided, in the divorce context, they decided that the mother couldn't, the father wanted to keep the embryos and the mother didn't, and they said that they could not force one to become a parent against their will, and
Different result.
So what do they do? Okay, so
we've had
different
a couple cases, situations in which couples come in, they start this process. It's long, it's draining, and we've had a couple of situations in which one parent wants to transfer an embryo, and the other parent says no. And we, our policy is you cannot force someone to be a parent. So most people
are they staying married and they're still saying no? This is not.
Yes, these people are still married
right, still maybe
saying,
not for long.
Exactly.
And Don better give him his card, I think.
So that's interesting. I mean, and so this is one. We were going to get to this. We got to it sooner than later here, but. Obviously, when people are trying to have kids, I mean, we're not just creating one embryo. We may be creating, 5, 10, 15, 20. And I know that there's a whole bunch of, political and religious agendas attached to that. But there are obviously legal consequences, and often something happens between the time those embryos are created and gestation of that embryo. So now we've got a situation where maybe they're contemplating divorce, and ownership becomes a real issue.
Absolutely. It's really important when you are counseling a couple who is going to engage in in vitro fertilization or creating embryos, what do they have any religious or social issues about embryos? So, for example, do they believe an embryo is life and that every embryo will need to have the chance to be implanted and to grow? You need to have that information because you don't want to create 20 embryos or 15 embryos or 10 embryos in that situation. That's not fair to the family. So, the reality is when patients are undergoing IVF, you're hoping to get 1 to 2 viable embryos at the end of each IVF cycle. So, most people are not going to have 15 or 20.
What's fascinating, the first test tube baby is back in 1978, so we're talking some 35 years ago. Now, here's what we couldn't do back in 1978. A same-sex couple could not be the biological parent of a child. A child could not be conceived posthumously. A dead person could not be the parent of a child conceived after his or her death. An infertile couple could not be given an embryo to gestate. A woman could not arrange to have the embryo planted in a gestational surrogate. A woman could not offshore her pregnancy. An embryo could not be tested. Sperm could be preserved, but eggs and embryos could not be cryopreserved for future use. I mean, look at what's happened in just 30 years. And, Don, we've talked about this before on this program, even in employment law scenarios. There's always going to be a technological burst that comes out on the scene. But the law is always forced to catch up. True, the law, technology comes first, the law works to catch up.
Yeah, it really does. We see it with the gestational surrogates, the contracts that are entered into. It's sort of, to some extent, a shot in the dark. I mean, you have these issues. You can't sell a baby, so if the surrogate's going to be paid, it has to be for expenses, pain, and suffering. And then, of course, the issue of some of the genetic testing may show that the child's going to have some issue.
Right.
If the contract may say that the parents have the right to terminate the pregnancy, but I think the surrogate probably has a constitutional right under Griswold to carry the pregnancy. So
wow.
We have all sorts. I mean, I'm seeing the issues of, okay, if the pregnancy is carried and the child is born with cystic fibrosis or something like that, Pennsylvania does not have a wrongful birth, does not permit wrongful birth litigations.
Right.
So the question is what the damage is.
We're lucky, and we now have the ability to do so much genetic testing on people before they even create embryos or get pregnant. Unfortunately, most sperm donors only require testing for cystic fibrosis. That is required on every sperm donor that we use. But we can now test for over 100 different gene disorders for women who are donating eggs, couples who are doing IVF. So we can.
So if they have the marker and it could be passed on.
Correct.
Okay.
If they have the marker, they could pass the gene on.
Right.
It's a pretty minimal risk, Juanita.
Yes, it's a blood test. It's a
Wow.
simple blood test. Can test for over 100 different gene disorders, and there are multiple organizations, companies that are coming out with this technology, and it's only going to get more and more extensive as time goes on. And then what do you do with that information? You know, you carry a gene for this, you could pass it on. Then now our patients also have to have genetic counseling on top of psychological counseling and legal counseling because you're opening a whole other area for them to explore.
Sounds like it can get pretty expensive, Juanita, but maybe that's the cost of having a child this way.
Yeah, well, it is very expensive, and unfortunately Pennsylvania is not a IVF mandated state or infertility mandated state, so most of our patients are paying out of pocket
Right,
for all
no
of their
insurance.
expenses.
Right.
New Jersey is a mandated state. There are 15 states that have some type of mandated coverage for infertility, but Pennsylvania is not one of them. So it is very, very costly. I mean, an IVF cycle starts, you know, in the $15,000, and when you don't have a guarantee of a baby at the end of it, that's distressing. So patients have to do their homework. They have to find the places where the pregnancy rates are good, being careful to make sure that they're not just looking at the numbers. There's much more that goes into that data than just the numbers, but it's important that they look at the numbers and listen to the provider when they're counseling them in the appropriate course of action.
You know, I would have to think that of all of these issues that we're talking about, the one that's going to probably strike the real emotional chord is the surrogate. Again, this is a woman who's allowing her body to be used as a carrier. And again, I guess there are two different ways you can do that. It could be the woman's own eggs, or eggs could be, you know, implanted, if you will, in that woman. How do you actually prepare someone, whether it's psychologically or legally, that once you start carrying that baby, you know, I know people take seeing eye dogs and they don't want to, you know, give the dog up after a couple of weeks.
Yeah.
Can I change my mind? No, legally you can't. Anytime that even when people sign that document, you feel like, boy, this may not be 110% airtight if the surrogate changes her mind?
Most of the time when we're doing surrogacy, we're not using the surrogate's eggs. Most IVF practices have gone to using just true gestational carriers, where it is the other woman's eggs or a donor egg fertilized with the intended parent's sperm, and then the embryos are placed inside the gestational carrier. That way they have no genetic link to the child, in that they're not donating their eggs or their sperm.
It makes it a lot cleaner, does it?
Well,
not?
it does, but you know, anybody who's been pregnant understands there's a connection between you and any child that's growing inside of you. So most of our gestational carriers are women who have had their own children, who want to give something back to someone else. So they enter into it with a clear understanding that they are giving this child to the intended parents, and that is an intended parent contract that needs to be put in place for that.
And so legally, that gives you folks, you know, things are clearer now than they were, you know, 10 years ago or so.
Well, I don't think they were so much clearer, at least not in New Jersey, because in that there was a recent case that came down and our Supreme Court went 3-3 on it, where they said, and I'm going to try to get this right, the only way they could ferret out what was going on is they used the Parentage Act, and they said because the father, I think it was the father's sperm in that case, he was presumed to be the father, so his name was on the birth certificate. The other woman was not her egg, so she couldn't be on the birth certificate. But his name could be on there because he was presumed to be the father under the Parentage Act. And we said that there was an equal protection argument. And why wasn't the mother, she wasn't the carrier, but the mother who was going to be the intended parent, why couldn't her name be on it? And they said it didn't fit within the confines of the Parentage Act. So that this is a perfect example of our laws, us trying to fit something into a structure that really wasn't applicable to these people.
Yeah, we don't have a Parentage Act in Pennsylvania like that. If it's a gestational surrogate, the case law is pretty clear that that gestational surrogate has no standing because there's no biological link. And then with that circumstance where it's a mother's egg and a father's sperm in the gestational surrogate, we can get pre-birth orders, which puts those parents' names right on the birth certificate.
Got it. And
New Jersey, we can't.
And New Jersey, you can't.
You have to wait till the baby's born, and then you have to go through an adoption process.
Wow. So we've come up with this new term in the law in the last 10, 15 years, intended parents. These are the people, and you would think, and again, they should obviously have standing. You would think that they would go right to the top of the pecking order. But Bonnie, thank you for the demonstration right out of the New Jersey Supreme Court that says not so fast.
But it was a 3-3 split.
Yes,
so
right.
even they are not.
Even the wise ones. We're talking about assisted reproduction technologies tonight on ALJ. How will this area of the law impact LGBT couples? More when we return.
This week's American Law Journal has been made possible in part by King Spry, serving its Pennsylvania clients in family law, business, personal injury, and school law for over 30 years. Einhorn Harris, a long-standing community law firm with the largest family law practice in New Jersey. And The Legal Intelligencer, the nation's oldest legal newspaper for lawyers.
What are the legal rights of parents who have a child created by the efforts of 5 people, 2 genetic donors, 1 gestational mother, and 2 intended parents? I know it takes a village to raise a child, but did we see this one coming? Welcome back to the program. We're talking about assisted reproductive technology on ALJ tonight. 3 esteemed guests with me. Bonnie Frost, partner with Einhorn Harris, Barbarito and Frost in New Jersey. Juanita Kness is with us this evening with Reproductive Medicine Associates of Pennsylvania, and Don Spry with King Spry, Herman, Freund, and Fall. Hey, Juanita, I see that Halle Berry, went out and at her age was able to have a baby. Do people come in and say, I want the Halle Berry pregnancy?
Yes, we see a lot of women in their early and mid 40s who want to become moms with their partners, and it's very distressing to them when we have to tell them that at their age the chances of getting pregnant using their own eggs is less than 5%.
Even if it's in vitro fertilization?
Even with in vitro fertilization. I mean, there's certain blood tests that we look at, but after 45 your ovaries start to age significantly, and the chances of pregnancy are dramatically reduced, even with IVF.
I don't know, Juanita, you have just destroyed my, what I thought People magazine had always told me with Kelly Preston and Halle Berry. I don't know.
I don't know that the situation personally, but I can say it's very unlikely that they got pregnant the old-fashioned way. Whether they had embryos stored or eggs that they had frozen earlier, I don't know. But it is hard for us, for our patients, to see those things and not want to have it replicated for themselves.
Now, again, one of the advents in this area of technology has helped, another issue that's moved down the family law track in courts, and that is the rights of LGBT parents, gay couples, civil unions, gay marriage, that sort of thing. Gay families can truly become a family scientifically, genetically as well.
And it's up to each individual fertility practice to determine the patient population that they will care for. You know, we look at everyone, we don't discriminate on the basis of sexual orientation, but it's obviously easier for the lesbian population to have children in that, you know, it's cheaper for them to buy a couple vials of sperm and do a fertility treatment cycle.
Compared to egg, sperm is cheap, right?
Yeah, well, yeah, compared to egg, sperm is very cheap. I mean, it's $300 to $500.
Put your own joke in here. I understand, right.
For a vial of sperm, but you know, to buy a half a dozen eggs or 10 eggs, you're
Right.
talking in
Costly.
you know, $15,000, $20,000, $25,000. That's a whole lot more than you're paying for some sperm.
Right. You just came off a trial, 5-week trial, right?
And one of the issues at the very end was what the couple was going to do with...
Lesbian couple?
Yes,
Okay.
with what the couple was going to do with sperm which had been frozen. And this had to do, however, with the contract with the company that was storing the sperm, because the company itself required both moms to sign off on the destruction of the sperm. But they had entered into a contract with the sperm donor that they were only going to use it for their children. And so the sperm donor anticipated by contract that once this couple no longer wanted to have any children, his sperm was not going to be used anymore.
And Don, we're seeing probably more and more of these cases as there's some clarity, at least from the courts, if not from the legislatures. They're mostly contractual issues, right?
Yeah, in Pennsylvania it's been treated that way, although the case where the embryos were distributed to the wife, there had been a contract which had provided early on that if one did not want to be a parent, they couldn't be forced to be a parent. And in that case, that contract was not followed. There was a balancing test that was done. I understand certain states use balancing tests and certain states are strictly contractual. It's sort of a mixed bag.
But then they went ahead and destroyed the embryos.
In the Pennsylvania case, the
Right.
wife received the embryo because she had was able to prove she was not able to have children as a result of chemotherapy.
I gotcha. I understand. You know, and probably, Juanita, you have people who probably say to you, hey, you know, we've got 10 or 15 here, we're going to have our kids, we've got these other 8, and you say, what do you want to do with them? And they tell you, well, we'd like to donate them. What do you have to tell them?
They can donate their embryos. We have a form that they have to complete, a legal binding contract once again. Sometimes they want to destroy the embryos. That's their right. They're their embryos. If they want to donate them, they can donate them either for research purposes or they can donate them for another family to use embryos. And
But you advise against that usually, don't you?
donating them other embryos
Yes.
to other families?
Yeah.
We don't, as I said, we don't allow them to make that decision until they have completed their families. But once they're done with their families, then
right.
then we have the option A, B, or C: discard, donate them for research, or donate them to another family.
Right. And by donating, of course, they relinquish all their legal
That's correct.
rights
They
as well.
relinquish all of their legal rights.
Says that in the informed consent contract, right?
Yes, it does.
I didn't see the clause, but I'm sure it's in one of those 27 pages, you know?
It's over and over.
They're getting almost as long as prenup agreements. Maybe not quite, Don,
Which is
but-
something else that you could address in a prenuptial agreement.
Yes.
Have you seen that in prenup
I
agreements?
haven't yet, but I
gonna see.
will
You're
do it if
anticipating.
the right. Yeah, I mean,
Yeah.
I think you have to try to anticipate these things. I think that's the hard thing with these contracts. I think, in that especially with the surrogacy contract, trying to anticipate the issues that could come up and then try to contract them away.
Yes.
Hey, Juanita, I wanted to ask you, you and your organization are there to be medical advisors. And of course you say bring in the psychological test results and you have your lawyer and that sort of thing too, but don't you size up people who come to see you? I mean, aren't you designed to see an octomom maybe coming a mile away? Don't you have to play part of that? I mean, I talk to the lawyers and say, you're a little bit of a psychologist. They say, no, but really sometimes they are.
Yes.
Don't you have to assess people, size them up?
That's part of the intake process when they meet with the provider, whether it be the physician provider or myself, and then with our nursing counterparts. So it's pretty easy to spot someone that you think may have some issues that need to be addressed, and we're pretty upfront with them about that. It may be drugs or alcohol. It may be parenting, whether they're truly prepared for parenting and do they really understand what they're getting into. It could be marital strain that they're not admitting to. So it's our job to make sure that we cover all those bases.
Right. And you can refuse,
yes,
obviously, working with them.
We have on occasion refused the care because the person has not done what we've told them they need to do in order to get that care.
Well, maybe it's not a brave new world, but it is an interesting future. Once again, 7.3 million people, that's 10% of the reproductive age population, have some sort of medical infertility problem. So you're going to see that, if 1 out of 10 of your clients, have this kind of an issue, it may not come up, immediately, but you're going to see it. So what's next in the so-called brave new world, Don?
Well, I mean, I think just very basically, our initial interviews are broadened. You have to ask those questions. Are you involved in infertility treatments? What have you signed? What have you not signed? Where do you stand with that? Because on a prenup situation, you can deal with it. If it's a divorce, you have to deal with it. But some of the facts are set already. So.
Now, we occasionally have a couple come to see us who is legally married to one partner and wants to have a baby with a new partner. They're getting older. They don't want to wait for that divorce to go through. And we have to tell them, we're not going to help you break the law. The law is clear on the fact that, they need to be legally divorced before they enter into starting another family. And their IVF consents say the same thing. If you change your marital partner, you need to tell us. So those are things we need to know.
Bonnie, where's this going next for you in your practice?
Well, all of a sudden I'm getting very worried that I'm not asking some of these questions in the initial interview. But and I guess I would be concerned if someone came to me and said they're in the middle of IVF and they want to get divorced. I mean, that's certainly a very sad event after all of that effort and angst.
You've heard of people asking for divorce when a wife is pregnant. As sad as that is,
Absolutely.
It's not unheard of. So what's next, Juanita, for your practice? What should people expect down the road here in the next 5 to 10 years?
Well, we're getting so much better at the embryology piece of creating embryos. We can now do chromosome testing on embryos to tell if the embryos are normal. We are now able to do single gene testing so that if if your child is at risk for cystic fibrosis, we can test the embryos before we put them back. So we are able to help increase the likelihood of pregnancy. The reality is the pregnancy rates, differ by age, as I said, and by practice. So patients need to be really looking at what those numbers are and be realistic about it. Patients come in, they want to have an intrauterine insemination with donor sperm and they think they're going to have an 80% chance of pregnancy. It's 20%, 15-20%. They need to understand those numbers, and it's a lot of times going back to them and saying, remember we talked about this? It isn't a 100% chance every time, because they get very disappointed if it doesn't work. So a lot of what we do is just needing to keep re-educating, revisiting what the reality is.
And no doubt lawyers and judges and state legislatures are going to keep their eyes on it. I'm glad we did that tonight. Bonnie Frost joining us once again from Einhorn Harris. Asher, Barbarito, and Frost, a partner in one of the largest, if not the largest, family law practice in the state of New Jersey. And again, Bonnie, the former president of the family law section for the New Jersey State Bar. Juanita Kness joining us for the very first time this evening with Reproductive Medicine Associates of Pennsylvania, nurse practitioner, an RN with a doctorate. Thanks, Juanita, for joining us this evening. And Donald Spry, once again, 23 years strong here on ALJ with King Spry, Herman, Freund, and Fall. For all of us here at the American Law Journal, thanks for joining us this week. Until next week, case closed.
This week's American Law Journal has been made possible in part by King Spry, serving its Pennsylvania clients in family law, business, personal injury, and school law for over 30 years. Einhorn Harris, a long-standing community law firm with the largest family law practice in New Jersey. And The Legal Intelligencer, the nation's oldest legal newspaper for lawyers.